Woodcock, principal lawyer at Leo Lawyers. You might already know me, or this is your first time visiting our video library. And while this looks and sounds like me, you're actually watching my AI avatar, speaking from a script that I've personally reviewed and approved. Today, I want to spend some time taking you through one of the most important legal frameworks for anyone operating in the Australian hospitality industry, the Hospitality Industry Award 2020, which we usually just call the Hospitality Award. Now, I appreciate that awards are not the most exciting topic for business owners. Many of you are focused on running your restaurants, hotels, bars, or catering businesses and ensuring your customers are happy. But from a legal and compliance perspective, the award is absolutely critical. Why? Because the award sets out the minimum standards for your employees. That means their pay, their penalty rates, their allowances, their hours, their breaks, their roastering rules, all of those day-to-day employment matters that are easy to overlook. And here's the key point. If you're not complying with the award, you are breaking the law. That can mean claims for back pay, penalties from the Fair Work Ombudsman, and damage to your business reputation. So today, I'll break down the award in a way that makes sense for employers. Let's get started. Award in a way that makes sense for employers. Let's get started. The first thing we need to understand is coverage. The Hospitality Award applies to most businesses in the hospitality sector. So we're talking about hotels, motels, serviced apartments, restaurants, cafes, bars, nightclubs, and catering businesses. It applies nationally, regardless of whether you're a small family-run cafe with 3 staff or a large resort employing hundreds. Unless your employees are covered by a registered enterprise agreement or another specific industry award, the Hospitality Award will apply. This means you can't opt out of it and you can't contract out of it. Even if you and your employee sign a contract that says something different, if that contract gives them less than the award overrides it. Now let's talk about classifications. Every employee who falls under the award has to be slotted into a classification level, and these classifications are quite detailed. For example, you've got food and beverage attendants, levels 1 through 5, kitchen attendants, levels 1 through 3, cooks and tradespersons, levels 1 through 5, guest service staff, levels 1 through 5, and then there are front office staff, clerical staff, and a range of others. Why does this matter? Because that classification is what sets the minimum pay rate for the employee. To give you a snapshot, as of July 2025, an introductory level worker is entitled to $24.28 per hour. A level 2 cook earns $25.85 per hour, and a trades qualified cook at level 4 earns $28.12 per hour. If the employee is casual, you also need to add a 25% casual loading on top of those rates. Here's where businesses often get caught out. Misclassification. Say you pay someone as a level 1 attendant, but in reality they're performing level 3 duties. That's a misclassification, and it's one of the most common mistakes employers make. If the employee challenges it, the business could be on the hook for significant back pay liabilities. Now let's look at penalty rates and overtime, an area that's especially important in hospitality because of the hours staff typically work. Hospitality really is a 24/7 industry. Staff are often working late nights, weekends, and public holidays, and the award makes sure they're properly compensated for those unsociable hours through penalty rates. For example, if someone works an evening shift between 7 p.m. and midnight, they're entitled to an extra $2.81 per hour. If they're working overnight between midnight and 7 a.m., that loading goes up to $4.22 per hour. Weekends are higher again. On Saturdays, employees are generally paid at 125% of their base rate. On Sundays, it's 150%. And on public holidays, it jumps right up to 225% of the base rate. Overtime applies as well when staff work outside their ordinary hours or beyond the maximum shift lengths. So, more than 38 hours in a week or more than 11.5 hours in a single day will trigger overtime. The rates there are 150% for the first 2 hours and then 200% for anything beyond that. Employers and employees can also agree to time off in lieu instead of overtime pay, but it's important to note that this agreement must be in writing and the time off has to be taken within 6 months. Another area where employers can get caught out under the award is allowances. The award contains a long list of them, and they can add up quickly if you're not across the rules. Some of the key ones include the meal allowance, which applies if an employee works overtime without being provided with a meal. There's the split shift allowance, which applies when a shift is broken into 2 parts on the same day. You also have the uniform allowance if staff are expected to launder their uniforms, and the tool allowance for cooks or trade staff who provide their own tools. On top of that, there's the first aid allowance, which applies when an employee is appointed as a first aid officer. What often surprises employers is that many of these allowances are classified as all-purpose. That means they're not just paid on top, they're actually rolled into the employee's rate of pay. And once that happens, they affect how penalty rates and overtime are calculated. And here's the risk. If allowances are overlooked or not applied correctly, it doesn't just mean small errors, and it can snowball into significant claims. Another area where the award sets very strict rules is rostering. Ordinary hours can't exceed 38 per week, averaged across a roster cycle. Shifts generally can't run longer than 11.5 hours, and employees must have at least 8 hours off between shifts. Rosters also need to be posted at least 7 days in advance, and any changes require proper notice. Break entitlements are also built in. Employees are entitled to a paid rest break of 10 minutes for every 4 hours worked, and an unpaid meal break of at least 30 minutes for shifts longer than 5 hours. Split shifts are allowed, but if you roster one, the split shift allowance applies. And don't forget the new right to disconnect provisions in the Fair Work Act. Employees cannot be required to respond to calls, texts, or emails outside of their working hours unless it's reasonable. The takeaway here is simple. Rosters and breaks aren't just an operational issue, they're a legal one. Getting them wrong can expose a business to penalties and claims for breaches of the award. Casual employment is another critical issue in hospitality, and the rules have recently tightened under the Fair Work Act. The industry relies heavily on casuals, but it's important to be clear on what that actually means. Legally, a casual is defined by the absence of a firm advance commitment to continuing work. But if a casual has worked a regular pattern of hours for 12 months, and that pattern is likely to keep going, then they're entitled to request conversion to permanent employment. In many cases, employers must actually offer that conversion. There's also a requirement for employers to provide every new casual with the casual employment information statement at the start of their employment. This is one of the most common areas where businesses slip up. Failing to manage casual conversion properly doesn't just create admin issues, it's often the trigger for disputes and underpayment claims in the industry. talk about record keeping, because under the Fair Work regulations, this is a legal requirement, not just good admin. Employers must keep detailed employee records, and that includes hours worked, pay rates and loadings, penalty rates and allowances, leave entitlements, and superannuation contributions. Pay slips also need to meet strict requirements. They must be issued within 1 working day of payment, and they have to show gross and net pay, hours worked for casuals and part-timers, any deductions, and superannuation details. All of these records must be kept for 7 years, and here's the key risk. If you don't keep proper records, the law presumes the employee's version of events is correct, unless you can prove otherwise. That means poor record keeping doesn't just create confusion, it can put you in a losing position before a dispute even begins. Let me finish by highlighting some of the most common mistakes we see in practice. One is misclassifying employees, paying them at a lower level than the duties they're actually performing. Another is forgetting the casual loading, particularly when calculating penalty rates. We also see employers ignoring allowances, with split shift and uniform allowances frequently missed. Roster changes without proper notice are another big one, where the 7 days notice requirement isn't followed. Then there's casual conversion, where businesses don't meet their obligation to offer permanency. And finally, poor record keeping. Things like missing timesheets or incomplete pay slips. Each one of these mistakes can lead to serious consequences, including significant underpayments, back pay claims, and penalties. But here's the bigger picture. Compliance is actually good for business. Some employers see the award as just red tape, but complying with it isn't only about avoiding penalties, it's about building a sustainable business. When employees know they're being paid correctly, they're more likely to stay, which reduces turnover and saves you on recruitment and training costs. It also protects your brand. In hospitality, reputation is everything, not just with customers, but with staff. Being known as a fair employer is a competitive advantage in a tight labor market. And finally, compliance reduces stress. When you're confident that your payroll, rosters, and records are correct, you can get back to focusing on what you do best, running your business. So, to wrap up, the Hospitality Award applies to almost every hospitality business. You need to classify employees correctly, pay the right rates, apply penalty rates, overtime and allowances, follow the rostering and break rules, manage casual conversion properly, and keep accurate records. Remember, compliance isn't just about avoiding penalties. It's about protecting your staff, your brand, and your business. At Leo Lawyers, we specialize in helping hospitality operators stay compliant with the Fair Work Act and the Hospitality Award. We conduct payroll audits, review contracts, and advise on compliance systems tailored to your business. If you're unsure whether your business is compliant, contact us using the details in the description box or visit us at leolawyers.com.au. Thank you for watching. See you in the next video.